So trust accounts. If I had to pick one area of ethics that every new lawyer should be very well versed on and very careful with, it would be attorney trust accounts. Sometimes they're known as IOLA accounts or IOLA TA accounts. It's interest on lawyers' trust accounts. Now, these are very different accounts. It isn't just any trust account. You just don't walk in your bank and say, I want to open a trust account. These are specialized trust accounts. Now, every jurisdiction has different rules, and you should obviously look at your particular rules. So what I'm going to be talking about is some general guidelines that I think probably apply in most states. First of all, that account is linked to your disciplinary committee. So if a check bounces or there's a problem with that account, your disciplinary committee is immediately notified, and you will be getting notification from the committee, and there will be probably an audit of your account. That should put a very strange, cold shiver down your spine if that ever happens. Also, the interest that's accrued on that account is given to the usually an attorney fund. Most states have funds that try to reimburse people who have been cheated out by lawyers. So you don't make any money on this. The interest goes right to the fund, and all of the activity on the account goes straight to the disciplinary committee. And what do you use this for? Let's say there's a house closing. Money goes into the house closing. You disperse it to the title company, the clients, the banks, etc. It could be a personal injury case, gross proceeds from the settlement or the verdict come into your trust account, and then you're the dispersing agent. You need to keep very detailed records so that every deposit and every account has its own account. So if you have, Smith v. Jones personal injury matter, you have a separate account. You're not just putting everything, dumping everything into the account. So that if somebody says, I want to know when the settlement proceeds on Smith v. Jones was deposited, where every check went, you can go right to that account and you can show that. Now, states have limits on how long you have to keep records for these accounts. And if you want to comply with it, that's fine. I, overcompensate in this area. I never throw them out. I keep them forever. Disciplinary committee wants to know a deposit 10 years ago, I can show it to them. It's not a big deal, especially if you have good electronic digital systems and applications to help you and assist you with your account. There's no reason why you can't have good records and keep them forever. The other thing you need to know about this is not your money. You cannot commingle your funds with the client's funds. You cannot use those funds. It's very tempting. If you have a large amount into your account, and lawyers do this all the time, and they lose their license to practice law. I'm going to take the money out of the trust account, I'm going to do something, and then I'm going to put it back. That doesn't work. The minute you take it out for your own use, you're probably disbarred in most states. Disciplinary committees don't play any games when it comes to fooling around with your client's money. Now, of course, in a personal injury matter, and I use that example, some of that money is yours, say a 33 1/3% of that. That's fine. And you disperse it appropriately. Some goes to the client, and some goes to disbursements, and some goes to you. But you can't deposit any of your money into that account. You keep your operating account separate from your trust account. So I could give a whole topic or a whole series on all of the rules that apply to attorney trust accounts, and maybe we'll put a video out going through those rules in detail. Those are just a couple of things that you need to keep in mind when you're setting up your account, and you need to be extremely cautious. It's the #1 best way to get disbarred.